You're listening to the Patenting for Inventors podcast with registered patent attorney, Dr. Adam Diamond, founder of Diamond Patent Law, the #1 source for securing your intellectual property needs. Now, here's your host, Adam Diamond.
Hello and welcome to the Patenting for Inventors podcast, episode 106, What Goes into a Patent Infringement Complaint. My name is Adam Diamond, a registered patent attorney and founder and owner of Diamond Patent Law in Los Angeles, California. I can be contacted through my website at diamondpatentlaw.com, that's D-I-A-M-E-N-T, patentlaw.com, or call me at 424-281-0162. In the past few episodes, I talked about the litigation process. I started with a broad overview of patent litigation and then went into the first step, which is either where you want to send a cease and desist letter or you've received a cease and desist letter. In this episode, I'm going to talk about the complaint. The complaint is the first formal step in a patent litigation lawsuit. It's where you actually file something with the court saying that you're going to sue another party for patent infringement. Things have actually changed in recent years about how much detail of patent infringement you have to put in the complaint in order for it to be considered a valid complaint. You used to be able to be very general and just say that the other party sold products that embody the patented invention. This was a very bare bones approach that was allowed. But there were some cases and then an actual rule change that made it much more clear about how detailed you have to be. But I'll get into that later. I've always intended this podcast to be a very practical podcast, as if you're doing everything yourself. There's a disclaimer at the end of every episode that I'm not giving you legal advice for your particular situation, and this is especially true in litigation. Do not try to do litigation yourself. But if you're working with an attorney, and if you listen to this podcast, you'll hopefully know what the attorney is doing and why they're doing it, and hopefully you'll also learn enough to ask some questions to your attorney about the whole process. In this episode, I'm going to go through a sample complaint and what is in it and why. Every case is going to be different, so there's no one-size-fits-all for patent complaints. The first page of the complaint is going to have some information about who is filing it, where it's being filed, what you're complaining about. I know that might sound kind of weird because you sound like you're a child complaining about something, so you can think of it as what you're alleging the other party has done. Different courts around the country may have different rules about what goes where and the font size and what goes in. For a typical complaint, but for a typical one, on the top left, you're going to have the people that wrote up the complaint. So it will usually be some attorneys' names, their state bar number, their email address and phone number. It will say attorneys for the plaintiff. The plaintiff is the one that's alleging that someone is infringing the patent. Below that centered, you'll have the court where you're filing it in. It will say something like, in the United States District Court for the Central District of California, or the Northern District of California, or wherever you're filing it. Below that on the left, usually you have a box, and on the top of that part, you list yourself or your company. So XYZ Incorporated, a California corporation, plaintiff. Then below that, you'll put in a V, which stands for versus. And you put in the party or the parties that you're alleging is infringing your patent. So it might say ABC Incorporated, a California corporation, defendant. And that's all that goes into that box. Then on the right, you say what kind of complaint this is. There are complaints for all kinds of things: personal injury, breach of contract. If it's a patent, you'll probably write complaint for patent infringement. And below that, you'll say something like demand for jury trial if you want a jury trial. All of this goes onto what's called pleading paper. Pleading paper is a specially formatted paper that has line numbers on one side and some other lines in other places, and it's just the format that the courts require. On the next page, you'll have a heading that says something like complaint for patent infringement. And you probably might have a single sentence that says something like, XYZ company files this complaint for patent infringement and demand against ABC company and alleges as follows. Then the next heading might be something that says the parties. In this section, you write a little bit about who the parties are. You'll probably write the name of your company, where it's incorporated, the address of the place of business. In the next paragraph, you'll write what you believe about the company that's infringing, the name of that company, and the address of that company. The next section usually is something about jurisdiction and venue. Jurisdiction and venue are about what court is allowed to hear your case. If it's a patent case, state courts are not allowed to hear those cases. Only federal courts can hear patent cases. So the jurisdiction is a federal court. And you write essentially that the Patent Act makes it so that the federal court has original jurisdiction. Venue is about what particular federal court is allowed to hear your case. If you're in California and you're suing another company in California, can you go to a federal court in Alabama to hear your case? Well, sometimes yes, sometimes no. But you have to make the argument about why this particular venue is an appropriate court to hear the matter. It could be that even though both companies are in California, all the sales are done in Alabama. There are all kinds of rules about venue and lots of fights about the appropriate venue because everyone wants a venue that's going to be the most favorable to them. But for this example, let's make it simple and say that you filed in the Central District of California and that you write that venue is appropriate because both companies are headquartered in the geographic region where the Central District of California is located. The next section often might be about what your innovations are. So you can put in what you made, how successful you've been. You can say what the problem was in the industry and how your products have done to help that problem. How much money you've spent developing products, how much your company's worth. You just kind of want to make yourself sound important. The next section might have a heading called Asserted Patents. You'll want to say your patent number, the title of it, and then say that a true and correct copy of the patent is attached to the complaint as Exhibit 1. You'll want to say why your company has rights to this patent. Was it filed in the company's name? Did the inventors assign it to the company? Did your company buy the rights to the patent? You'll want to say what the patent is generally about, such as I've talked about before, an avocado slicer that has 3 tools in one. Then you might have a section that has a heading about the notice that you gave to the defendants. Here you might write the timeline of when you sent the cease and desist letter to them and that they've continued to make and sell the product. You can say what products you discussed in your cease and desist letter or your telephone conversations and say that they're still infringing, that you discussed with them on certain dates what they were doing. And maybe you tried to enter licensing agreements with them, but they refused to enter them. You probably wanted to go into some detail so that you can assert willful infringement. Because as I talked about in a previous episode, if you can prove willful infringement, you can get what are called treble damages. That's 3 times the amount that you normally could be owed. In the next heading, you might have something called defendant's products. Here, you'll go into details about what products the other company is selling that are infringing your patents. You might want to provide images of these or website screenshots and say that they're included as an exhibit and that you're attaching at the end of the complaint. You can be fairly detailed here and talk about all the features that these products have. You don't actually want to write about infringement yet. This section is just about their products and what their products do. The next section could be a section where it's called defendant's infringement of plaintiff's patents. Here you can write that the defendant is infringing your patents, what products they are, and this might be a very short section. In the next section, which is really a subsection of the previous one, you might write count 1. The reason why you write this is because there might be lots of different types of patent infringement. There could be direct infringement, there could be indirect infringement, and I have podcast episodes on those 2 types of infringement as well as others. And let's do the simple case of direct infringement. So below subsection that I called count 1, you might write direct infringement of patent number X, and then you'll put in your patent number. You'll then put in several paragraphs asserting that they're infringing your patents because they're making, using, importing, selling without your permission from you. You'll list the products again that are infringing. You'll say why they're infringing. You'll say that this product does X, Y, and Z, or it has X, Y, and Z, which is patented in your patented claims. You'll write about how you'll suffer harm by the defendants if they continue to sell their products because you're losing sales, or things like that. All the things that are happening to you or your company because they are infringing your patents. There might be other counts you want to add, and you put those in different subsections about infringement. If you have more than one patent, those would be under different counts, and you would talk about the different products that are infringing all the different patents. You might have 5 counts or 10 counts or more, just depending on what kind of infringement's going on. Maybe someone's infringing your trademarks as well, and that would be part of the complaints, but I'm focusing on patents for this series. The count section is the part where you used to be able to be a lot more lax and not as detailed, but now you really should be detailed here. At the end, you'll have a section called Prayer for Relief. This is what you're actually asking the judge to do, and there are a few things that typically will go here. One is an entry of judgment holding that the defendants have infringed your patents, so you want the judge to actually say, the defendants are infringing the patents. You probably want a preliminary and permanent injunction against the defendant from infringing your patents. You'll want to ask for an award for past damages no less than a reasonable royalty. You can ask for a determination that the defendant's infringement has been willful, and that's so you can get treble damages. And you also want to ask for a finding that the case is exceptional. The reason you want to do that is that if a case is exceptional, you can get attorney's fees. This is another reason why you want to be detailed in how the defendant infringed your patent. And also, it kind of goes hand in hand with willful, because the more willful and egregious the patent infringement is, the more likely it will be found exceptional. You might want to ask for an accounting of all infringing sales and revenues with post-judgment interest. And this is so that you can actually see the sales and other things that this company has been doing in order to determine your actual damages. And you'll want to catch all at the end, saying, such further and other relief as the court may deem proper and just. This is just if you miss something and you're asking the judge just to do the things that are proper, just in case you didn't specifically ask for it. The attorney will sign the complaint at the end, and if you want a jury trial, you'll have a page saying that you demand a jury trial. You sign and date that page too. And pretty much that's the basics for a complaint. You file it with the court, and you have to serve it on the defendant, and they have to answer your complaint. Now, in order to serve a complaint, you have to get someone called a process server, and they usually hand deliver the complaint to someone at the company headquarters, but there are other ways of doing it too. Generally, the defendant has 21 days to answer the complaint. This is why you should not ignore a complaint if you get one. Talk to an attorney right away. Usually, both parties will agree in the beginning to extend the deadline, and everyone tries to be a little bit nice in the beginning with each other, and if one party wants an extension of a deadline, the other party will usually agree, because you never know if you're going to be on the other end of that, and you're going to need an extension down the road. And if you start saying no to extensions, guess what's going to happen? It's going to come back to bite you. So unless there's a really good reason not to agree a deadline, you probably should do it. And if you want help with your patent application, trademarks, copyrights, responding to rejections, appeals, or anything else related to your invention, you can contact me directly through my website at diamantpatentlaw.com. That's DIAMENT patentlaw.com, or email me at adam@diamantpatentlaw.com, or call me at 424-281-0162. I'm Adam Diamant, and until next time, keep on inventing.
Thanks for listening to the Patenting for Inventors podcast with host Adam Diamant. If you enjoyed the show, please rate and review on iTunes. The contents of this podcast are intended for general informational purposes only. The facts of every legal matter are unique, and the content of this podcast should not be construed as offering legal advice for your specific legal situation. For more information and help with your own intellectual property needs, contact Adam Diamant at patentingforinventors.com. That's patentingforinventors.com. or call Diamant Patent Law at 424-281-0162. The preceding information may be considered an attorney advertisement and does not establish any attorney-client relationship.